Sarah, what exactly is a mental health examination or independent medical examination, and when might it be necessary in a divorce case?
A mental health examination is when one spouse may be exhibiting erratic behavior and the other spouse asks the court or the spouses agree that the spouse in question should undergo a mental health examination. An expert is appointed depending on their process. Typically, an interview takes place, at least one interview, and that expert then issues a report to the court. This can have an effect on a child custody determination. As far as compelling your spouse to have a mental health examination, you can certainly ask the court for that. It depends on what their behavior has looked like. If they are sending harassing text messages, if they're driving erratically, if they're abusing substances, things like that, especially if there's a child in question that they've placed into harm's way. Things like that can greatly affect your chances of success. As far as paying for the mental health evaluation, it may behoove you as a litigant asking the court to order this mental health examination to offer to pay those costs up front, but those can always be subject to reallocation at final trial. Results of the mental health evaluation can, like I said, have an effect on a child custody determination. It is likely that your spouse will agree to undergo the mental health evaluation without any sort of quid pro quo. A lot of times litigants agree to undergo bilateral mental health evaluations to sort of take the sting out of that request. Or more commonly, one litigant asks the judge and the judge will deny or allow that. More commonly, one litigant will motion for a mental health evaluation, usually against the other litigant's wishes.